Today we will focus on director's duties because that is one of the most common examinable topics in company law exams. Company law is a very broad subject and there are a lot of topics. So it is important that you focus your attention on the big ones that most likely come up on the exams, like director's duties. Firstly, I'd like to remind you about the what kind of style you need to be following in problem and essay questions. In problem question, you should be identifying what is the legal issue in the scenario given. You need to discuss the relevant law, identify the correct law, the statute, and the cases. Companies Act 2006 is the starting point, and then the relevant cases. You need to apply it to the facts of the case and provide analysis. You don't need to give an accurate answer because we don't have one particular answer in law. You need to give an overview of all the possible answers. That is a good analysis. Essay question style is a little bit different because here you don't have a problem question scenario given, but you have a particular area of law for critical analysis. Here as well, you need to discuss the relevant laws and explain what is the law in question, the legal issue in question that is subject to critical analysis, explain the relevant statutes, relevant case law, but very important is to not become descriptive. A lot of students lose their marks in essay questions because they just explain the law without giving any arguments and critical analysis. So it is important that you limit the explanation of the law to a certain extent, but 50-50% with the analysis. So you explain what is the law and then you provide the analysis. How does the law that you explained refer to the question asked? How does it answer the question asked? What is your argument? What is your point? And then you need to provide a good conclusion, which is answering the question asked. We can start from what are the general duties of directors. And here are the general duties: duty to act within powers, duty to promote the success of the company, duty to exercise independent judgment, duty to exercise reasonable care, skill, and diligence, duty to avoid conflicts of interest, duty not to accept benefits from third parties, duty to declare interest in proposed transactions or arrangement. In a problem question, it is important that you identify on the scenario given which one of these duties apply, and then discuss the relevant statute. These duties are set out from section 170 to 214 and state which one of the sections is the relevant, what is the duty, what the director has to do to breach that duty, and then apply it to the facts of the case of the problem question given. Do directors owe a duty to shareholders, employees, or creditors? The answer to this question is that usually no. Directors owe duties to the company rather than the shareholders. Shareholders are not directors' employers. The company is the employer. Company is a fictional body that has been registered and it has a separate corporate personality, as we have already seen in the case of Salomon and Salomon. Personal versus right is an exception to this principle. Directors only owe the duty to the company, not directly to the shareholders. Directors only owe the duty to the company, not directly to the shareholders. That is the authority of this rule, that directors owe duty to the company rather than to the shareholders. There are exceptions to this principle, and for example, in Breeze versus Worley, directors owed duties to the shareholders concerned because directors had undertaken to sell the shares to the shareholders. By doing this, they had put themselves in an agency position with the shareholders and were liable to shareholders. So the general principle is that the directors owe duties to the company rather than to shareholders. But in certain circumstances, if directors have done a particular act, it could give rise to agency relationship, as it is demonstrated in the case of Breeze versus Willie. But these will depend, the duties that arise similarly to the case of Breeze versus Willie is not based on the Companies Act 2006. It's based on agency law. So it's different area of law. Fiduciary duty, directors owe fiduciary duties to the company. Fiduciary means trust and confidence. So when somebody is in a trusting relationship, confident relationship, that person is called a fiduciary, which equity protects. It's an equitable principle. Equity protects by imposing on the fiduciary a duty of loyalty. And the case that you can cite for this principle is Bristol and West Building Society. You need to remember that in a problem or essay question, when you're explaining, giving definitions to the principles, any principle, whether it's fiduciary duty or anything else in any area of law, you need to always cite the relevant authorities. Usually the definitions we have from case law, so you need to cite the relevant case, or if it's a statute, you need to cite the relevant statute. Regal Hastings versus Gulliver, an important case that you need to remember. The case concerned a solicitor, the solicitor was imposed strict liability for all unauthorized gains made by the fiduciaries deriving, however, obliquely from their fiduciary duty. In Regal, defendants were 4 directors of the company who earned profit by exploiting a business opportunity for themselves. So the strict rule is that somebody in a fiduciary relationship cannot have any conflict of interest. If there is a situation of conflict of interest, then that fiduciary can be liable for the profits made, because it's a strict rule. A fiduciary cannot earn any personal profits by exploiting a company business opportunity for themselves. In this case, Lord Russell stated, the rule of equity, which insists on those who by use of fiduciary positions make them liable to account for any profit, and that liability in no way depends on fraud, absence of honesty, or upon any question or consideration of whether the profit would or otherwise have gone to the plaintiff, or whether the profitee was under a duty as to the source of the profit, or where he took a risk or acted as he did in the benefit of the plaintiff, and the plaintiff has in fact been damaged by the action. The liability arises from the mere fact of a profit in stated circumstances being made. The profiteer, the fiduciary, however honest and well-intentioned, cannot escape the in-court account. It is a very important statement by Lord Russell. He explained basically what is the idea of the strict liability imposed on fiduciary duties and in what kind of circumstances this can happen. He said that just by making any profit from the position of fiduciary, doesn't matter if the person was honest, it doesn't matter what was the level of dishonesty or fraud, if fraud was committed, or if he didn't take that opportunity, it would anyhow benefit the company. None of the circumstances matter. It's a strict liability, and as long as fiduciary makes any profit from his position as a fiduciary, then he will be called into account for those profits. And a case on this strict liability that we should analyze is Plascorp Ltd versus Pike, which is an exceptional case. That is why we think that you should be aware of this case, and probably you will need it in a problem question if you have problem or essay question on this topic. Mr. Pike was a director of the company. The other director excluded him from the company. So he had a disagreement with other directors to fight, and he had to leave. He then set up a new company while he was still a director of Plus Group. It was held that no liability was found on these facts because there was no breach of fiduciary relationship. He did not use any secret information related to his previous company. So, unlike the principle that was explained by Lord Russell in the previous case, that case was decided in 1942, so a long time before 2002. So things has changed a little bit, and in this case, although he did set up a new company, the court said that he did not breach any fiduciary relationship because he just didn't use any secret information. So they did have a look at the background circumstances, which was that he was not being dishonest. He was excluded from the company. The directors didn't want to work with him anymore. So he was not dishonest. He did not use any secret information. He basically didn't do anything wrong. So, and the court did take that into consideration, despite of this strict rule. This is an exceptional case and difficult to reconcile with a strict approach, such as Rico versus Gulliver. Had Mr. Pike been a non-executive director of Impulse, it would still have been difficult to see how he could have used information acquired while on company business for his personal gain without there being some suggestion of at least conflict of interest. If you have a look at other cases, you will see that the judgment focuses on usually conflict of interest. And as long as the courts see a conflict of interest, they usually say that strict liability will be imposed. But this case was different. There is also under section 171, duty to act within powers. A director of a company must act in accordance with the company's constitution, which is articles of association, only exercise powers for the purposes for which they are conferred. A case about this principle is Howard Smith versus Ampol Petroleum. Lord Wilberforce explained, when a dispute arises where the director of a company made a particular decision for one purpose or for another, or whether there being more than one purpose, one or another purpose was a substantial or primary purpose, the court, in their lordship's opinion, is entitled to look at the situation objectively in order to estimate how critical or pressing or insubstantial an alleged requirement may have been. If it finds that a particular requirement, though real, was not urgent or critical at the relevant time, it may have reason to doubt or discount assertions of individuals that they acted solely in order to deal with it, particularly when the action they took was unusual or even extreme. In simple words, what Lord Wilberforce is saying is that the court will take into consideration all the background circumstances to decide whether or not the director acted within their powers. Obviously, this is a very difficult task, especially in a problem question for a student to decide whether or not the director acted within their power. So my best suggestion would be to cite the relevant cases, explain what Lord Wilberforce said, that all the background circumstances have to be taken into consideration, and it has to be critically analyzed whether or not what the decision has been taken was critical, was urgent, was necessary. Say what you think, and always based on the authorities. I'd suggest you have a look at other relevant cases as well, and if you can find any similar facts of the case from the facts that you have been given in the problem question, that would be useful for you to compare, for you to say that on the similar facts in this case, the court found that the director acted within their powers, or the contrary, and then say if most probably the court on the facts that has been given in the problem question could apply the same reasoning or not. So have a look at all the possible scenarios, obviously mention the relevant cases, and say what are possible outcomes. You cannot give an answer. You cannot say whether or not director acted within their powers or not. You just need to give critical analysis, all possible outcomes, explain what are possible outcomes, on what basis and why. Interests of employees. Under section 172(1)(b), directors must have regard to the interests of the company's employees when considering how to act in a way that would most likely promote the success of the company for the members of its members as a whole. So this section can also be relevant in a problem question that you may have on this topic. So you need to be aware that directors also have this duty. Interests of creditors are usually not a requirement under the Companies Act. It's not a duty. However, there are exceptions, like in this case of Nicholson versus Permacroft. Once directors know that the company is insolvent or doubtfully so, they owe fiduciary duties to creditors. So they cannot negligently keep spending the monies if they know that the company will most likely go insolvent and there are creditors to be paid. In that case, they will owe duty. They will owe fiduciary duties to creditors. So what kind of questions you can get on directors' duties? There can be problem questions as well as essay questions. And problem questions on this topic are usually where you need to discuss if directors breached any of their duties. And essay questions where you need to critically analyze directors' duties. Example, if directors have the power of management of the company, they alone can exercise these powers. Critically analyze. This is one of the common essay questions that can come up. So what are you going to discuss? How are you going to answer this question? Well, firstly, you need to give definitions. You need to explain a little bit about what are the directors, what is the role of the directors in the management of the company. Then mention if there is anyone else who also has power within the management of the company. And then give the thesis statement, say that you will discuss whether or not the directors are the only ones who are the main decision makers in the company. And in the body paragraphs, you could probably give arguments for and against, arguments for supporting that, yes, directors are the main powerful figures in the management of the company, and they are the only ones who can exercise these powers. They do have a lot of powers, but they don't have absolute power. There are some discretion on, for example, shareholders have also some powers, like resolutions, ordinary resolutions, and special resolutions need to be mentioned as well. So you need to have arguments on both sides, showing that these are the powers of the directors, which is significant, which shows that when it comes to everyday management of the company, yes, they are in charge. However, there are certain matters that they do not decide, and say what are those matters. If you need any help with answering that question or any other similar questions, I suggest you have a look at our tutoring services. Our tutors will be able to assist you with any question you may be struggling with. Example problem question. We have a lot of essay and problem questions. You can have a look at our website. For example, this is an extract from one of the problem questions we have on this topic. Pick and Drive PLC run various car rental services. Article 3.4 of its constitution states that a part of the profit obtainable for dividend purposes is to be paid by a certain date once a year, and that this is not dependent on the directors and members making any decision to declare or pay a dividend. However, nothing has been paid for 3 years. Pick and Drive PLC main cars are located in central London. various directors of Pick and Drive PLC, who all hold shares of the company, always drive the cars around the city for free whenever they wish. The CEO, Mr. Patel, is determined in attempting to win corporate business for the cars, in particular conference reservations, yearly meetings. As a result, he spends more time amusing rich corporate bankers, investors, and clients rather than doing the business. As a result, he usually receives as expressions of appreciation expensive gift cards, free bookings at five-star hotels, and designer clothing. So probably you can see here the facts show that there are some conflicts of interest involved here, and there are some you need to discuss Regal Hastings principle, the strict duty that could be imposed on the directors if they have some personal benefit, if they obtain some personal benefit from their fiduciary position. So this can be one of the problem questions that you could be given. We have a full answer to this problem question on the website, and it's a level of analysis that is expected on an exam where you have very limited time. It's not a coursework level answer, but I suggest that you have a look very carefully and understand how you are supposed to write the answer to these kind of questions. This is the extract from the answer that we can read. The next issue to discuss is potential breach of fiduciary duty, as set out in section 175. So as I said before, the starting point should be the statute, the relevant provision, section 175. It states that a company must avoid a situation in which it has or can have a direct or indirect interest that conflicts or possibly may conflict with the interests of the company. The section is a codification of an equitable principle of no conflict, no profit rule, which was established in Bray versus Ford. His lordship argued that it's a flexible rule of equity, that a person in a fiduciary position is not, unless otherwise expressly provided, entitled to make a profit. It's called the no profit rule. He's not allowed to put himself in a position where his interests and duty conflict, the no conflict rule. In the present case, directors are using the cars free of charge several times a year. So as you can see, first we started, we stated what is the issue. The issue is potential breach of fiduciary duty under section 175. Then we continued by discussing what is section 175, what is the fiduciary duty we're talking about, what is the relevant case, Bray versus Ford. We explained the principle, and then we apply it to the facts of the case, which is our structure. Applying the above principles, it would amount to conflict of interest because they are exploiting the business properties that they are not authorized to do. However, it can be argued that if they get approval under section 239 of the Companies Act to use the cars whenever they need to, it would no longer amount to conflict of interests. If they disclose all the information and if they get approval from the board, then it is less likely that they can be sued for a breach of their fiduciary duties. The similar case to consider would be Regal Hastings versus Gulliver, where directors earn profit by exploiting business opportunity. It was held that directors of companies are fiduciaries and therefore similarly liable to account for profits made in the conduct of their duties. Applying the reasoning in the instant case, the directors here are fiduciaries and shall be liable to account for profits made in the conduct of their duties. Moreover, under section 177, directors are liable to declare interest in proposed transactions or arrangements for the company. The directors must declare the interest to the other directors. So they have to be honest, they have to declare if they have any personal interest in their fiduciary duties. So if they have to use company properties for personal purposes, that can be conflict of interest, and that can be exploiting the business properties for their own benefit, and they should disclose that information. Applying the principle, Directors of the company use the cars must have declared it with other directors and have approval. Also, Section 182 states that directors must declare interest in existing transactions or arrangements of the company. Therefore, depending the directors of the company must have declared their interest under Section 177 or under Section 188. As you can see, the analysis are not very detailed because, as I said, this is the level of analysis you are expected to write in timed exam where you are under very, very tough time conditions. But it very clearly shows you how you're supposed to give the examiner the ARC structure, how you're supposed to explain the law and then apply it to the facts of the case, and what kind of referencing you're required to do and what level of analysis you can give. This can be about 2-1 level answer for an exam. The full answer can be read on our website at this link. When you receive the slides, you will be able to have a look at it. And I highly recommend you to have a look at other example answers as well. We have about 10 example answers on different topics in company law, and it is highly recommended that you have a look at all of them. Also, reading notes is very important. First, you need to have the information about what is the relevant law, what are the cases, what are the statutes, explanation of the principles, and then you need to practice. But most of the students forget the second part, which is also very, very important. So I suggest that when you decide which topics you're going to prepare for your exam, you read the notes and then you practice by answering a problem or essay question on that topic that you revised. You really need to do both, because if one thing is to know the law and the other thing is to be able to apply your knowledge to the problem and essay questions, which is a different skill. It's called legal writing skills, and it really requires time and practice. I suggest you really put your time in it before company law exam to practice as much as you can answering problem and essay questions. And our example answers are designed specifically to help you with that. How can we help? At SimpleStudying, we have a team of very successful law graduates and law students who have all achieved high to 1 and first-class grades in their respective law examinations. And we have created simple study materials to help you achieve the same success as we had in the simplest way possible. Our simple notes are specifically designed to help you get top grades, and they are on point to give you just the right information, what you need to know from our own experience to get the best grades possible. Example essays, very important content for you to be able to understand how you're supposed to answer problem and essay questions. Tutorial videos are perfect for visual learners, where you can really learn by slides and from this kind of sessions, or even animated videos. We also have animated videos where you can learn cases. Quizzes and flashcards are great for visual learners as well, who like studying with practicing. Quizzes and flashcards are designed to test your knowledge. Study and exam tips are everywhere on our topics. We share exam tips all over our notes to help you understand how you're supposed to apply the knowledge to common problem and essay questions. If our resources are not enough, we also have tutoring services where you can meet one-to-one with the tutor and understand anything you may be struggling with. Tutor can help you with planning your revision for an exam, preparing for an exam, reviewing your coursework, helping to do legal research, anything you may be struggling with. It's a one-to-one personalized support for students. We have already helped thousands of law students get high grades. Our regular students get a first class after studying regularly with our platform, both our simple study materials and occasionally tutoring services as well. We would like you to be our next student to get a high grade join SimpleStudying now. Thank you for your attention.